name is Joanne DiPietro. I'm an attorney. I work out of Walpole. This is my 25th year practicing law. And one thing that I have to say to you is, what does practicing mean? Practicing means that I'm still learning, and that's the truth. And my high school daughters think that that's the craziest thing that they've ever heard, that I still have to learn in my 50s. But it's fun, and I love my job, and I love what I do. And that's why I like to come to these sessions with you, so that I can share the knowledge that I have to help you make your decisions to reach your goals, and make sure the people that you leave behind, we give them proper directions as to what they need to do. So today we're going to talk about wills and trusts and estate planning. And again, I'm welcome to questions. Please just raise your hand and I'll come to you. You can ask the question, or I can repeat the question. We want to make sure the people at home can hear what you're saying. The other thing that I want to remind you of is I'm not giving you legal advice. We're just sitting here chatting today. If you need legal advice, I'm more than happy to assist you one-on-one. However, I do encourage you to speak with the attorneys that you have currently if you have a plan, to make sure that you understand the plan that you have and if there's any updating that's required. So let's start off by talking about a will. A will is the foundation of your estate plan. What happens if you die and you do not have a will? Then that means everything goes through statutory law. That means your assets will go to your heirs at law. So if there's any reason that you don't want to give assets to a blood heir, your children, your spouse, your nieces, your nephews, whoever it is in that inheritance line, you need to put it in writing. All of the documents that we're going to speak about today is about you being heard when you can't vocalize or someone can't hear you, whether it's due to death or incapacity, okay? So if you have particular wishes, you really want to make sure that you'll be heard. And not only will these documents protect you, but they will protect the people that you choose to speak for you. Those people are called fiduciaries. A fiduciary role is when you appoint someone to speak for you and they have a certain duty. If they are in breach of that duty, that's not a good thing at all. It actually has a higher standard than a parent-child in Massachusetts, because you could be subject to criminal action if you abscond with money or anything like that. So when you're choosing your fiduciaries, you also want to make sure that you're choosing the proper people. Make sure that they know what's going on. Make sure that you trust them. You know, we're all talking about things that cause emotions. When someone becomes incapacitated or dies, we're still human beings. And certain emotions come up within a family, with friends, whether it's this one got treated better than me, or this one's resentful about this one. I have clients come into my office and they say, oh, my kids all get along. And I'll say, great, until they don't, right? I don't care if it's $5 million or $5. We're still human. We're still going to have emotions. So the best way that you can alleviate any problems for those people that you leave behind is to make sure you've drafted a proper estate plan. Yes, sir.
What is the difference between an executor and a fiduciary? Like, I have an executor, but you were saying choose a fiduciary. I'm sorry to ask the question.
No, that's a wonderful question, because we're still talking about wills. And the fiduciary, think of it as like the umbrella. And then we have different people that get assigned for different documents. Within the will, you appoint the executor or the executrix, which is now known as a personal representative. It's the same definition of that role. They just changed the name. But it actually works better, because think about it. It's the person representing the decedent, the personal representative. So if you hear PR out of my mouth, I'm referring to a personal representative. And within your will, you appoint the personal representative. Normally, spouses will choose each other unless someone's incapacitated, they lost their marbles and they can't do it. And then usually they'll have a child, or you have a friend, or even a professional to appoint to the court. The will is taken to the court and it's proven and allowed. We get a stamp by the judge. Now that personal representative has authorization to speak for the decedent. And guess what? You can't do anything anymore without authorization, right? Have you even tried to get blood test results on a family member? Can't do it. You need authorization to do everything. Another reason why you really need to make sure your estate plan's up to date. And you're going to hear me say that a lot. So the will is also taking care of two types of property. One, your tangible personal property. That's everything you can see, feel, touch in your house. Your jewelry, your television sets, your furniture, your coin collection, your baseball collection, your great-great-great-grandfather's great-grandfather clock. Whatever it is that you own as of your date of death, you state where your tangible personal property is going to go. If you have specific items to go to a specific person, a diamond ring, a 1969 Corvette, whatever it might be, you can put that on a memorandum of intention that I give my Corvette to my nephew Bobby. He would love to hear that. The next thing that your will is going to provide for is all the rest, residue, and remainder. So anything else that is in your name individually travels through your will, because it doesn't already have somewhere to go. So let's just talk about that for 2 seconds, and we're going to talk about probate court. So if I take my glasses, and these are nice Versace glasses, and he made them himself, so they're worth a lot of money. But these aren't held jointly with my husband, like my house is. Husband and wife, tenants by the entirety. So when I die, my 50% interest of the home will immediately go to my husband, Doug, because we own the property, husband, wife, tenants by the entirety. These glasses have nowhere to go because they're not held jointly, nor is there a beneficiary. My daughters are not the beneficiary of these glasses. For instance, a life insurance policy. That document with the cover sheet, the declaration page, tells you the payout of after death. The beneficial interest says it goes to a particular person. That asset travels outside the will contractually because it has somewhere to go. Let's go back to the house for an example. When I die, again, my interest immediately goes to Doug because it's rights of survivorship. But then guess what we did? We created a probate asset for Doug because he owns it individually now, and when he dies, it has nowhere to go. Get it? Okay. Why do we care if it doesn't have anywhere to go? The probate court now takes jurisdiction of the home because their job is to accumulate, marshal, the personal representative, does this, takes those assets to probate court. Probate court has the jurisdiction to make sure it gets to the proper heirs at law or beneficiaries. Go back 2 seconds. Heirs at law if you didn't write a will. If you wrote a will, who did you leave the house to in your will? Okay? One of the sheets has some glossary of terms on the back of it. So some of the terms that I'm talking about, you can reference that as well for you. Going back to the will. That's the basics of the will. It's actually pretty simple when you think about it. It's named your fiduciary. It's stating where your personal items are going. And then it's stating all the rest, residue, and remainder. So think of personal of things that you can pick up and take. You can't pick up and take a house. You can't pick up and take a bank account or a CD or an investment account. So that's how to determine the two differences between tangible and intangible. So now I'm going to get a little bit more complicated. Let's talk about trusts. Before we get into trusts, I recommend that you pull this sheet out. This is a little cheat sheet for you. Remember like the, what were those things called that we used to read when we were in high school? Cliff Notes. This is like the Cliff Note version. They're called Spark Notes now. That's what I hear. The youngins, that's what they call them. This is the Cliff Note version of trusts. There's two different types of trusts. There's a lot of trusts, but there's two types that we're going to talk about today. There's revocable and there's irrevocable. And this gives you a little breakdown of them. It tells you the advantages and disadvantages of either of them. Now, I like to explain the revocable trust as a 2-layer document. This is the actual trust document that I'm looking at. When I create the document, I am the trustee. Let's say myself and my husband are the trustee. Unfortunately, my husband predeceases me, so I'm the sole trustee now. Upon my losing my marbles, I become incapacitated. I no longer have the capability to act as trustee. So within this trust document, I have appointed a successor trustee who can immediately jump up and take care of everything that is in this trust. Okay? When you put property into this trust, it's called funding the trust. You're putting your assets into the trust. A home is put into a trust by signing a deed. Signing the deed of me individually that I'm conveying my property in Walpole over to the trustees of the trust, which happens to be me also, but it's a different fiduciary capacity. It also will allow us to avoid probate upon the second of us to pass. Make sense? Okay. The second part, this underlying part, is the equitable interest of the trust. You are still keeping dominion and control over the assets you put in here, okay? Even though you're acting as a trustee, you can use the money, you can still mortgage the house, you can sell the house, you can do anything you want with it. We're still using our own social security numbers, we're not getting another tax identification number, you haven't gifted anything. So it's still yours, but for estate planning purposes, you've put it into the trust so that we can avoid probate upon the second to die, or allow the successor trustee to jump right up when there's death or incapacity, okay? This is a very valuable tool. And I say to my clients that I've worked with, you know, I might torture you a little bit on all the work that we're gonna do now, but later on, we're setting it up to make it easier for the people that you leave behind. Another question?
Well, I was going to say, getting back to the first question that I asked you, is that does the trustee have to have expertise? Like the one who's my trustee is 80 years old, and he doesn't have any specific financial knowledge or anything, but I trusted him when I did that, but that's when I was 55 and he was 60. So that's what I was mixed up about the fiduciary business too.
That's not a mix-up. That's a very good question, because who do you appoint? We touch base on that. You want to appoint someone that you trust, someone that's going to make sure that your trust administration or your probate administration is going to be properly taken care of. The documents state within it if they need to hire a professional, whether it's an attorney, a CPA, an appraiser, whoever it is, they have the right to do that. Okay, so if your trustee is confused on what things need to go on, perhaps they'll reach out to your current financial advisor or your current CPA. If you are questioning whether they have the capacity to do it, that might be a time to do an amendment to your trust and replace that trustee with a different person.
No, thank you. I don't have a financial advisor or anything. I'm the advisor, so that's what I was confused about it. Like people do what I say. Thank you. I'm sorry.
No, that's okay. Thank you for your questions. That's very helpful. And like I said, someone else may have the same question. Are there any questions on the trust so far? Hold on, Carol. I'll come right there.
When you put something in a trust, you can't have a mortgage, correct? It has to be totally, the house has to be.
It depends on the type of trust. Carol's question was, if you put a home into a trust, which is conveying it by way of a deed over to a trust, can you have a mortgage on the property? The answer to that is if it's a revocable trust. Let's talk about mortgages for a second. When you take a mortgage out and you say, let's use Walpole Cooperative Bank since their name's on the front. Hi, Walpole Cooperative Bank. I want to borrow $200,000. They say, great, you qualify, you got great credit, all that kind of stuff. What's going to happen is I'm going to sign the note individually because they're going to want to make sure that if I don't pay, they're going to want to get into my pockets if I'm in default to get money from me, okay? So I'm going to sign the note individually, but my house happens to be in a trust. So I'm going to sign the mortgage as trustee because your mortgage always matches your deed. Okay, we're jumping into conveyancing world, but that's great because it all swoosh together. Because I have a revocable trust, and that underlining layer of the revocable trust, I have not lost dominion and control of the property. You can have a mortgage on it. Okay? The type of trust that you can't is the irrevocable trust. That's a flat trust. Think of a flat piece of paper. There's not two layers to it. I have now gifted my home to that irrevocable trust, and I've lost dominion and control. So the reason why I can't have a mortgage on it anymore is because I don't own it. So I can't mortgage something that I don't own. And with an irrevocable trust, depending upon your questions, we'll see how deep we go with this. With an irrevocable trust, you gift it away, you lose dominion and control, and it remains alive while you're alive. Think of it that way. You have the right to live there during your lifetime as a tenant. You don't have a possessory interest in the property like a life estate or actually owning a property. You get to stay there and you get to pay all the bills. But then upon your death, it goes to the beneficiaries that you named in that irrevocable trust. Okay? Some people immediately, I want to protect my house from creditors. Number one creditor is a nursing home. But sometimes moving a home into an irrevocable trust isn't a good product for everyone. So that's why when you come to us, we look at all of your assets so we can determine what's a good plan for you. Generally, if you have enough assets to live on and you don't need to tap into that equity within the home, an irrevocable trust may be a good product for you. And then we have the dreaded 5-year look-back period. Okay? What does that mean? That means if you convey a property today, January 18th, 2024, creditors can still try to tap into that for 5 years from now. That's the law. Why do we have a law? Because people were conveying their property in anticipation of a creditor coming to put a lien on their property, which is called a fraudulent conveyance. So the longer I practice law, that's what I see, is that the laws come about to either protect us from ourselves or protect us from fraudsters. So that's why when you say to an attorney, I want to protect my home from a nursing home, that's fabulous. But we need to look at the whole scope of what's going on to see if it's a good product for you. Okay, I have one more question back here. This gentleman, Jim. Can you...
Can you have multiple executors for either a trust or a will? And would you advise against or for that?
Yes, you can, is my answer to you. And I wouldn't do it as my second half of my answer, generally. So under a will, it would be a personal representative, and under a trust, it would be a trustee. And there's different reasons to have personal representatives or co-trustees. It's good to have co-trustees for checks and balance, especially if money's being held for an incapacitated adult or an incapacitated child who's under the age of 18. You can most certainly have co-personal representatives under an estate unless it's not really necessary. If it's a smaller estate, usually, because everyone still has to assent if they're heirs at law or if they're receiving a bequest in the will, everyone has to assent to that person. So you can do it, but I like to try to minimize the fees and costs for the probate administration. So I recommend to my clients, really, if I'm working with one person, it's going to be less time and effort than working with two. But if you feel as though you need a checks and balance, two people looking at all the numbers and everything that's going on, you most certainly can do that. Great question. Thank you. Anything else on wills? Oh. Thanks, Jim. Can you grab that?
Hello. Irrevocable trust. At one point, it was 3 years. Am I correct on that? And
It
then
was
went-
3 years. It's
went to
5
5.
now.
Who makes those jumps and why?
The state.
Reason?
Because one is a majority of the reason that people put property into an irrevocable trust to lose dominion and control over it is because eventually they're going to owe someone money, which again could be a nursing home. Let's talk about that for 2 seconds. When you go into a nursing home, you pay out of pocket. Everyone walks in that door and they're a private pay person. It's like renting an apartment for a month. You pay on the first of the month and you get to stay there till the end of the month. And then it starts your term starts all over again. Once you have the capacity to spend down your money to become eligible for Mass Health Services, which means you say to the state, who passes the laws, I'd like you to pay for my 24-hour nursing care. And if you have only $2,000 in an account and have $1,500 burial account, they'll say, okay, you've become eligible and we will pay for your 24-hour nursing care. There's 2 things that's going on, Ralph. People are living longer, and there's a huge baby boomer. There's a huge baby boomer generation that are all starting to move into these nursing homes, and some people do need help. Really, it's economics. Why could it be extended to 10 years instead of 5 years? Because if the state is giving out too much money and we're running out, it could happen. You know, there's a correlative also with Social Security, whether we're going to have enough Social Security for people. So the look back period from the 3 to the 5, from the cases that I've read, it was more so about people hiding money and, you know, having the ability to, you know, fudge a little to become eligible for the Mass Health Services. So now it's 60-month look-back period, and they will pull they'll ask you for all your bank statements, and they want to see where every single dime went to make sure you weren't giving away money in anticipation of a debt. Yes, 1 second.
Did I read that they are looking at moving into 7 years?
You'll read stuff that says 7 years or 10 years, and it could happen any minute. So when people ask for advice about applying for Mass Health Services, I'll say, well, today it's this. So when we're doing our planning, which all of this planning, you know, we don't have a crystal ball. We don't know exactly when and if something's going to happen. So we want to try to plan accordingly. So right now it's 5 years, but it could be 7, it could be 10. It depends on how much is in the bucket for people to use. Yes, thank you.
So the 5-year look back, is that for everything, stocks, money, your entire estate, not just your home?
So the rule is whatever you have dominion and control over. Okay. If you can, and this goes along with estate taxes too, which we'll talk about too. So I just want to put it in everyone's head. Whatever you own as of the date that you say to the state, I need help, whatever you could have sold or bought or mortgaged or whatever it is includable in your assets. So just like your date of death, the IRS takes a snapshot in time of everything that decedent had as of their date of death to calculate estate taxes, ESTATE.
So gifting, if you gifted, as long as it was before the 5-year period.
Correct.
You're
then
okay.
you're safe.
But
if you start to show that you're giving the exemption amount to 10 people every year, which in 2024 is $18,000 per person, every year you can give to someone, and you did it last year, and then you're going to say to the state, hi, pay for my health care, they're going to pull back that $180,000.
if it's over the 5-year or not even?
If it's under the 5-year period.
Under the 5-year, okay.
Yeah.
Okay.
Yep. Thank you. He's got another question. Yes.
Regarding the 5 or the 7 year, if I created my trust today and it's 5 years and they jump it to 7 tomorrow, is it 7 or is it 5? The look back.
So the look back is whatever the law is when you're trying to use the look back period for something.
So if,
Doesn't matter the date of the trust.
so if I dated it today and then change it tomorrow to 7, it's 7 years look back.
So we're talking about an irrevocable trust?
No revocable. No
Okay.
irrevocable. No, revocable. Sorry.
Yes, so a revocable trust, you still have dominion and control over it. The clock starts ticking when you lose dominion and control over this cookie jar, and I put it into an irrevocable trust. And if it's been in there for 5 years, and now I want to keep it away from a creditor, it'll be fine. If it's only been in there for 3, there's a potential that the creditor could get at some of it.
But if the law changes to 7, then does it go to 7 years?
Yes.
Okay.
Yes. Giselle, do you have a question? Oh, okay. I thought you did. Just saying hi. Thank you.
If you ask for health care, mass health, when you die, don't they take from your house that you have to pay them back?
That's an awesome question. It's like I planted you there. Yeah. So what my friend is talking about is estate recovery. Because guess what? Even though you ask the state to help you pay for your 24-hour care, they're going to try to get as much money back as possible. And the way to make sure that that doesn't happen is to avoid probate. Why? Because under the law, they can only go after the probate assets, those individual assets that have traveled through the probate court. Go back to the hypothetical. I die, my husband's in 24-hour nursing care, the house is still there, the house has to be sold to take care of him, but he got $150,000 from Mass Health Services to pay for his health care. When he died and the house was sold, and that house had to travel through probate because it had nowhere to go when he died, it was not in a trust, then Massachusetts Estate Recovery, that's the department, they will put a lien on the estate, and guess what? Their lien can never be discharged. There's some creditor liens that do get filed in a docket at the probate court that get discharged for different reasons. The IRS, the Department of Revenue, and Mass Health, they never go away.
I had a friend that happened to her. Her husband died. He was on Mass Health, and she said within, it seemed, days they were there with their hand out.
Because as soon as you file a probate docket, we have an obligation when we file a docket with the probate court to tell the Department of Mass Health that someone is deceased. And if we don't do it, we actually have liability. Yeah. So the other thing that they can go after too is if you're receiving Mass Health health insurance. If you've received Mass Health health insurance and you die and there's a docket open at the probate court, Mass Estate Recovery can also go in and try to get that money back as well. Yeah, it is interesting. And those are the nuances because, you know, some people will say, oh, I have a really small estate. I don't need a trust. And I tell them, give me 10 minutes and I'll tell you why you do. Make your head spin. But that is a really good reason. There's a lot of good reasons to avoid probate. You know, and Colleen Brierly, she was so nice. She came here a couple of months ago, but she's not offended when I say avoid probate. You know, it's not a bad thing, but it's time and money. But it exposes your estate to creditors. That's what it's doing. So if you can, again, help those that you leave behind, it's the best way to make sure things get funded into that trust. It's like your own family company. Because not only is everything nice and organized, and I definitely like organized, but also people can speak for you immediately, okay? So with that segue, if we don't have any more questions on wills and trusts, I'm going to pop over to the other documents.
The last question.
Yes, sir.
Is there any particular advantage, like if you have years ago it was very complicated for me, but if it's pretty simple, is a will just as good as a trust, really?
Great question. See that sheet right there? Can you pick that up for me? The first one, right under the business cards. What this will show you are the advantages right down here and the disadvantages of only having a will and having a trust. If you only have a will, probate's required. Because you have one asset, it has to travel through the will. But had you already put it in the trust, you don't have to go through probate. There's no privacy, because if you have everything in a trust, we don't have to file a probate docket, which is public knowledge. It's a public court. Everyone can look at those records. If you have a trust, we can do a trust administration without anyone knowing about it, what's going on with it. For a will, there's costly fees and delays upon death. Why? Because if you have a trust, that trustee can immediately step up. If you only have a will, that personal representative takes that will to court in front of the judge, has to prove that that's an original will, and it has to be stamped, and they need to be appointed personal representative, which that can take 8 to 12 weeks to do. So during that 8 to 12 weeks after someone dies, you're kind of in like a little purgatory mode because nobody can speak for that decedent.
Thank you very much.
You're welcome. And then no asset protection. Remember we talked about if it goes through probate, your creditors can still come after it. Okay? Yes, 1 second.
Yes, I was told if your estate goes to probate, it's a year and a day before everything is finally settled.
Good question. How long do you have to be in probate for? Generally, most cases are open for 18 to 24 months, depending upon the complexity of the assets and what's going on. The question was, does it need to be open for a year and a day? That is absolutely correct, because creditors under statutory law have 1 year from the date of death in order to file a claim against that decedent. Okay, so that's why when we file a docket in the probate court, we immediately have to tell the Commonwealth of Massachusetts that there's a decedent that they could potentially go after for recovery. Then what happens is when a personal representative is going to be appointed, a citation is issued. You know the back of the newspaper where you see the legal notices? That's what it is. A citation is issued by the court. We have an obligation to publish it within a newspaper that's circulation within the decedent's address where they lived as of the date of death, and people have a certain time to object to that person being appointed. I've only seen a few icky ones over my years of practicing. Generally, the estate plans roll nice and smooth. Once that person gets appointed, then the whole world knows that this personal representative can be contacted because the decedent didn't pay his JetBlue card, his Nordstrom card, his Macy card, whatever it might be. And they may put claims within the probate docket. And then that's when we talk about, do they have to perfect the claim? Do they have to file a lawsuit? Again, IRS, Department of Revenue, and Commonwealth of Massachusetts never have to perfect their claim. But that's correct. Statutory law, it has to be open a minimum of 1 year. Any other probate questions? No? Thanks for coming today, Vanna.
I don't know.
Yes.
Can a trust overrule a will?
Two different types of documents. Tell me what you mean by overrule.
Well, if you already have a will and you have somebody who's going to take care of the will and you don't want to use that will anymore, do you have to go through another lawyer, or can you just have the trust overrule the will?
No, two different documents. So a will is the foundation of your estate plan. It tells us kind of where to look. So you can have a trust, like you can put a house in a trust and it would act independently of the will. But when a person dies, they need someone to speak for them, and they need that personal representative to speak for any of the assets that they held individually. If you have a trust completely funded, then it should work properly. But if you do not like your will because perhaps the person that you appointed as personal representative is either incapacitated or they died, I suggest that you write what's called a codicil to a will, or you can rip it up and do a brand new will too. But a codicil is an amendment to a will. An amendment is an amendment to a trust. If they're conflicting, then absolutely, you definitely want to, write a new one.
Do you have to have both a will and a trust?
You do not.
So if you have a trust, you don't need a will.
Well, it's not that you don't need a will. Yeah. So let's go back to what a will does for you. It names your personal representative. So if you have all of your assets in a trust and everything has somewhere to go, but then your house gets sold, and this is a prime example that happens all the time, and the insurance policy that you paid in advance, the insurance company, they cancel it, the insurance company sends us a check, and it's payable to you individually. No one can cash that. Under the Uniform Commercial Code, no one can negotiate that check. So that's an asset that has to travel through probate court. So there's different types of filings in probate court. There's a voluntary, there's an informal, there's a formal, but that frequently happens. Our clients, we wrap up a trust administration, then 3 months, they're like, what do I do with this check now? There's no one to sign it, because that's forgery if you sign it and you try to deposit it. So we sometimes, if it's under $25,000, we can do what's called a voluntary. And we go to the court and we say we want John Smith to have the authority to open an account, an estate account, to negotiate this one check. And that's it. So it would be better if you had a will, because I don't know, maybe you don't want John Smith to negotiate that check, but you want to make sure your daughter can do it. So this is where you have to be heard. If you want to be heard in a certain way and you want someone representing you, make sure you have a will. Anything else on that? Okay, so why don't we switch gears to what I call the Saturday night documents. Those documents that you need in a hurry. Durable power of attorney, healthcare proxy, HIPAA authorization. Again, you're appointing fiduciaries to speak for you. A lot of times these are documents that are necessary to avoid probate. Here we go, avoiding probate again. If you do not have a power of attorney and you get into a car accident and you lost your marbles upstairs and you don't have a power of attorney, no one can speak for you. So your closest heir, your spouse, your kid, whoever it might be, will have to file a guardianship with the probate court. So now we've involved the court. And what does that mean? They want accountings on a yearly basis because they want to make sure, let's say I get appointed, they want to make sure I don't take off with all your money, right? Because you probably need care and things like that. So let's avoid the probate court by drafting and signing and properly executing, which is very important, with 2 witnesses and a notary, what's called a durable power of attorney. Durable means it lasts after the person becomes incapacitated. The person that assigns the durable power of attorney is called the principal, and they name an attorney in fact. Do you want to be my attorney in fact? Okay. So I'm going to tell her everything that's going on with me because maybe I have a diagnosis and I don't know what's going to happen in the future. And she's going to say, okay, great. What do you want me to do with this? What do you want me to do with that? During my lifetime, upon my death, my durable power of attorney dies, which is why you need a will, so that the person in the will can now speak for you. Durable power of attorney, there's all kinds of powers of attorney, but the one we're talking about, they literally slip into your shoes to take care of all your financial stuff. It also has HIPAA authorization. My nurse friend here knows you can't do anything if you don't have HIPAA authorization. That's the federal privacy rules on medical records. You can't find out anything, even on a loved one, somebody you're married to or even your own kid. My daughter just turned 18. She was in the office the other day signing a durable power of attorney, healthcare proxy, and HIPAA authorization because she's going to college next year. Yeah. So because she's 18, all the moms are asking me about it too. So we have a student special we're running right now. Well, I try to make sure everybody's all set because I know if something happens, they're going to call me anyway.
I have a question.
Yes.
Let me think about it. Oh, my God. No, not yet, I don't think. If if you have a trust and you have that all down, living will, everything's included, is that okay? It stays that way. In other words, what do you call it? Durable power of attorney, and everything you want done or don't want done. I got it specifically. No code.
Yes,
no
yes.
IDs, no medications. If I can't drink, just let me die. Comfort.
Does it really say that?
No, it says comfort measures only. Yep. So
Yeah.
that stays.
Yes. So let's say you lost your capacity and you can't sign your tax returns anymore, or you've decided to sell your home. If your home's not in a trust, your attorney, in fact, that you've appointed can take care of all those things. If there's a problem with the insurance company because you had you fell and you had an MRI and they won't pay for it and somebody has to fight with them because it's $40,000, those are the documents that you want to use, because a trustee is only dealing with the assets that are in the trust. Okay, so these are like the day-to-day things that happen. So that's the durable power of attorney. The healthcare proxy that she mentioned, of course, is with respect to all healthcare decisions, including a living will declaration. If something happens to you and you're found to you have no brain waves going on upstairs, they might put you on machines to make sure all of your organs are still working properly so that they stay healthy and blood's running everywhere it needs to be, but there's nothing going on upstairs. Do you wish to be kept alive with those extraordinary measures, aka machines? So if you haven't told, let's say I'm going to make it 5 children now. If you haven't told all your children that you don't wish to be kept alive on machines, it's not going to be pretty when the one who's supposed to be in charge of your healthcare proxy and there's no living will declaration that you do not wish to be kept alive with extraordinary measures comes up. I've seen it. Half my job is playing devil's advocate when I meet with people. You know, I'm by no means a pessimist. However, I've seen all these things come around. And a HIPAA authorization is important too. It's a document we've been using now for probably about 20 years, and I know not just my clients, but their children or their caretakers love it because it's a quickie 2-page form. Because sometimes whoever you're dealing with, if you send them the 11-page durable power of attorney, it's only good as who's looking at it on the other end. So a quickie 2-page HIPAA authorization gives you authorization to move x-rays from one place to the other, you know, or whatever it might be. Okay? You just couldn't wait for this mic, could you?
Do you need to have, or can you have 2 power of attorneys?
Yes, but that's even stickier than having 2 co-personal representatives, because again, they're the Saturday night emergency documents. And what if those 2 people disagree on what you want? Maybe you said to one of them, a lot of nurses will come in and say, I don't want dialysis. I know it's good for my kidney, but it sends the toxins everywhere else. And one of them says, yes, she wants it. And the other one says, no. And you're laying on the table waiting like, hey, what's going on? I prefer you only have one. I will absolutely draft it for you, but just telling you that these are decisions that have to be made quickly. And if they don't agree, these documents don't have a black and white referee t-shirt language in them. There's no way to figure it out within the document. Could end up in court. Any questions on that?
The saddest thing I ever saw in the emergency room was a 98-year-old woman who died, and she did have a paper, not with her. Once she hit our doors, we had to do code on her, and she came back. We called her a 68-year-old daughter who lived in some country. She said, you keep my mother alive until I get there. And it was 2 weeks in ICU before that poor thing could die. Yeah. It was sad.
Yeah. It is. It is. Well, the good part that we have now is most of us work with a medical group that has portals now. So, for instance, I go to Brigham and Women's, which is now Mass General as well, and you bring your updated, we're going to talk about that in 2 seconds, your updated healthcare proxy. to your primary care provider, and they can upload it into the portal, and any of those hospitals within that network, they can pull it up immediately. So that's nice about technology. So why do we want to update? So it's not that it's a written rule that your durable power of attorney or your healthcare proxy need to be updated even if you're not changing your fiduciaries. Again, this people that speak for you. But if they're older than 5-6 years old, the presumption, red flag goes up, that there could have been a potential that you updated it and you made someone else your attorney in fact or your healthcare agent. And look at it from their perspective. If they're listening to someone that they don't really know is the agent that was appointed, that brings them liability. And hospitals and banks don't want liability. So, you know, I do some work for some of the lenders. I get a phone call. Susie Smith has a durable power of attorney for Aunt Alice. It's 15 years old. What does Susie Smith want to do? She wants to take out all of Auntie Alice's money. Nope, not happening. It puts the onus on her to prove that it hasn't been extinguished, but that's what they have to do because otherwise the bank would have liability. So I do suggest that when you leave here, you get some homework, you go home, you see how old your durable power of attorney, your healthcare proxy is, for ages, for time, you know, how long ago were they drafted? And then the next thing to do is for your whole estate plan, look at all the people that you appointed. Are those people still alive? Are those people still capacitated? Do they have all their marbles upstairs? Or perhaps your life has changed that you're no longer living where you were when you drafted them 15 years ago, and your next door neighbor isn't your next door neighbor anymore that you appointed. So every so often, you know, life is busy, but every so often, and you know, this is a good time of year because you're starting to collect everything for your taxes, pull out your estate plan, sneak a peek at it, and make sure that it says everything that you wanted to, okay? Make sure it's updated. Yes.
What about do not resuscitate? If you had a DNR and you're in the hospital and you're pretty sick, and you tell a loved one's visiting you, and you say to them, I want them to resuscitate me, I've changed my mind, and that person leaves the hospital, you go into cardiac arrest, they do not resuscitate you because they had a DNR on you, but no one reported that she changed her mind. What kind of legal problem does that present? What does it?
A big one. But that isn't something that you would cover in your healthcare proxy. When you're talking about DNRs or feeding tubes or intubation, when you're either older or you have a diagnosis, you can work with your primary care provider on what's called a MOLST form. Yep, M-O-L-S-T, Massachusetts, I always forget the acronym, but it's life-sustaining treatment, the LST. So what that is you fill that out with your physician because your physician has to know that you had the capacity to say whether you wanted to be resuscitated or not. In your hypothetical, we don't know if the patient was capacitated, but it also should have been transcribed to a medical provider. So does it put liability on that lay person that they told them? No, because they don't understand the mechanics of it. But usually when someone's being taken care of, whether it's in a hospital or at home, and they have those objectives that they don't want to be resuscitated, you'll find that form taped to the refrigerator. Okay? That's something that you do with your primary care provider. You have to have capacity. You have to know what you're talking about when you say, I don't want to be intubated. Because a healthy person, if they get intubated, it may just be for a day or an hour. So you don't want to cut it off completely. So that's why it's a physical examination and it's a long process with the primary care provider that knows their medical history.
Who makes the call whether you're incapacitated or not. Like I once had an incident where they wanted to send me to a rehab, and the person and I told the people at the hospital, he's fired. I don't want to go. But who does make the call?
So your medical provider would make a decision as to whether someone has the capacity. Clearly, there are tests that are done to see if they have the capacity, which means they have the ability to make decisions for themselves, whether it's taking care of themselves or financial ability or whatever it might be. You're very welcome. Thank you. Ralph has another question. Jim's coming.
If that's in your will,
What's in your will?
that you don't want to have any, you just want to go in peace and that's it.
That's your healthcare proxy or a
Right.
most form, not in a will.
Not in a will.
No, that's not a material term for a will.
Okay.
Think of a will comes out when somebody dies. A trust is in existence while you're living. That's why it's called a living trust, and it provides for distributions upon your death. Durable power of attorney, healthcare proxy, those are the everyday ones that are hanging around.
Right. Okay.
And always retain those originals, by the way. Make sure you have multiple copies of the fully executed one. Because if Ralph gives up his durable power of attorney, his original, and then he loses his marbles, because he doesn't have capacity, we can't sign another one. So always retain your original durable power of attorney, healthcare proxy, HIPAA authorization. Let them see it, but pull it back. Let them make a copy or give them a copy. Okay?
Thank you.
Anything else today? I got a couple more questions.
Is it best to keep those documents at home or in the safe deposit box?
Oh, I don't like safe deposit box because they're closed on the weekends. Don't tell Walpole Cooperative Bank I said that. Unless you have, if you do have a safe deposit box, make sure there's an outside person on that safe deposit box, a child or whoever it might be. If it's just you or it's just you and your spouse, God forbid if you and your spouse were in an accident together, because the only way you can get into a safe deposit box is by a court order, okay? So if the person that owns that safe deposit box is deceased, you have to get a court order to get into it. So always make sure you give someone else permission to get into that safe deposit box. But also, banks are closed on the weekends and federal holidays. So I suggest that I like my clients to have a waterproof, fireproof safe at home. And if there's a code or a key, make sure they're there. A lot of attorneys will actually keep your originals, but they're also closed on the weekends. No. Right, but we prefer to see original wet signatures. That's not a field of law that's going to have electronic signatures on them. And that's why we always use blue ink when we sign, so that we know it's the originals, because we want to make sure that there's no fraud. Okay, you had a question as well.
I have a question. I have a question in terms of the cost of all of this, especially if you're starting from the beginning.
So the cost is, the determination of the cost depends on what we're doing for you. Because it could range from a simple will, and if you have everything joint, then we don't need to do a trust, to you could have a sophisticated plan because you have an estate tax upon you die, that you have more than $2 million. So the cost is relative to how much time and effort's being put into it. So unfortunately, I can't really give you a quote because I don't know. That's why I said I torture my clients to get all of their information so we can figure out a plan once I know what your goals are, and then we determine what documents we're going to draft to meet those goals. So it's kind of a hard question. Anything else? Oh, here we go.
I just have a question. We've talked about survivors and people that would inherit things, but we haven't talked about beneficiaries, like for financial accounts.
Okay. Yeah. So that would be a non-probate asset then, because it has somewhere to go when you die. Very good question. So if you have an IRA, a CD, a financial account, an annuity, when you work with your financial advisor or the bank to set those up, make sure you're signing that beneficial interest, schedule of beneficial interest, beneficiary certificate, whatever they call it. Make sure you fill that out, because if you don't, it becomes a probate asset. If you have a joint tenant on that account, then it'll go to that joint tenant upon your death, but then again, there's going to be a probate asset then. So who do you designate as your beneficiaries? Usually your spouse first, and then if your spouse predeceases you, then your children. Now there's one, and all of those can be moved into a trust also, the ownership title of the trust. So the beneficiary would be whoever's within the distribution of your trust. The only things that you do not move into a trust or change your ownership is an IRA account. An IRA account under the IRS code is an individual retirement account, which means an individual needs to own it. And then we get into the laws about the inherited IRAs and things like that. So the best thing to do is talk to your financial advisor, but generally, an individual owns it, make sure an individual inherits it as well. Okay? Did that answer your question? Good. More.
The bottom line is that it becomes, when you talk about an estate planning, that the beneficiary money is, if you, let's say you distribute all of your investments through beneficiaries, that's not part of your estate? It is, okay.
Thank you. So when we talk about an estate, we have a few different roads that we travel. We talk about the full value of all of the assets that you had dominion and control over as of your date of death. It could be a house that's in a trust. It could be a second home that's not in a trust. It could be IRAs, investment accounts, whatever it might be. And an individual person, if it's more than $2 million, then we have to file an estate tax return. So that's one road that we travel. Then the other road that we travel is getting those funds to the beneficiaries or the heirs at law, depending upon if you've designated within your trust or if you've done it contractually by way of a beneficiary certificate. So when you say an estate or asset, it includes everything. And other than things that they gifted more than 5 years ago. Okay? Anyone? That's it? All right, well, thank you all very much for coming. I appreciate it. Happy New Year, and make sure everyone stays healthy this year. Take care.